Hello everyone, in this video I'm going to be answering more of your questions, so without further ado I'll begin with the first one. I was reading today that the CCRC has 39 case handlers, including 9 who are part-time, so a very small organisation. The starting salary for a case manager is about £40,000, so it's hardly big bucks for a seriously important job. The Letby case is arguably the biggest miscarriage of justice in history. Are the CCRC equipped for it? So I think a broader question, before I answer that question directly, would be, are the CCRC adequately equipped? Full stop. And I think the obvious answer to that question is no. Ultimately, the CCRC can only be as equipped as they are funded. If they are underfunded, then they will struggle. We've seen exactly the same basic law of nature occurring in the NHS. So I think, broadly speaking, the CCRC are not equipped for the enormity of the job they have to do, given that the number of unsafe convictions is clearly increasing all the time, it would seem, based on what I've read at least. In terms of whether they're equipped to handle the Letby case, I think it's clear that in Lucy's case, they've made it something of a priority, whether that's due to its seriousness, whether that's due to it being high profile. They have made an effort, and I think as well we should credit them with attempting to. They've been sensitive to the criticism they've received, and they've made efforts to restructure and take on board some of the criticism and try to reform, and we should give them credit for that. Overall, they're not fit for purpose, but that's not entirely the fault of those that work for the CCRC. It's also, in my view, a funding issue. Do you think the prosecution has the stomach for a retrial if the CCRC refers the case back to the courts? Well, I can give you a little bit of a steer on this, because Mark McDonald believes that the prosecution will definitely push for a retrial if the case collapses at the Court of Appeal. Now, there will be a kind of joint decision made by the Court of Appeal and the Crown Prosecution Service. So, as far as I understand it, the Court of Appeal can stymie the retrial immediately and say there isn't going to be a retrial. As far as I'm aware, they have the power to do that. Whether they would do that, I don't know. All of the legal ins and outs are very complex and very much open to interpretation, so it's difficult to say exactly what would happen, but Mark says the prosecution will push for a retrial if the case collapses at the Court of Appeal. It's then another matter as to whether the authorities, whether the Court of Appeal could block it, I don't know. Whether the Crown Prosecution Service would have the stomach for it, I don't know. The fact is that it's looking very likely that it would be a very difficult retrial for the prosecution in terms of being outgunned. So, in a way, that kind of public process would be quite embarrassing for the system and for the Crown Prosecution Service, arguably. But then it's going to be equally embarrassing if the Crown Prosecution Service says we're not even going to contest this enormous criminal case where we achieved 15 convictions, 15 life sentences. The prosecution wants to retry the case, but we're now we feel we're in such a tenuous position that we're not even going to take it back to the court. That would be embarrassing as well. I should mention that Dr. Evans won't be in a retrial. As far as I understand it, he is required to appear at the Court of Appeal because he's in the original case, but he won't be in the retrial. What topics have you written about in the past, and where have you published or posted your writings? So I'm going to deal with this question as quickly as possible because it's not an important one, but as I mentioned, I've been a ghostwriter. I've written many books. Many of those books are published. It's not always possible. Broadly speaking, it's not really good practice for me to mention which books that I wrote as a ghostwriter, and I've signed non-disclosure agreements for many books. I've written a published novel as well. So yeah, I'm fairly published already. You may have seen some of my writing on Reddit as well. Why do I think Lucy Letby is serving multiple life sentences for crimes that may never have happened, found guilty on such flimsy evidence that didn't prove anything? Why, for what reason, was the guilty verdict absolutely vital for the police, the court, the NHS, the consultants and the CPS? Why did all the individuals and agencies need her to be guilty? Give me your view on why, Chris. Well, this is a deep philosophical question. The first thing I'll say is, you mentioned the police, the court, the NHS, the consultants, and the CPS. I think out of those groups, the court is the one that least requires a guilty verdict, because the court will just continue anyway. The NHS, you could say the same thing about. Whether that hospital, the Countess of Chester, would have benefited from a guilty verdict is another matter entirely. I think, broadly speaking, once you get so far down the line, there's been so much effort and so many resources, it becomes, we've mentioned this term sunk cost fallacy. They just don't want that to be for nothing. And I believe that's a big part of why Dr. Evans wasn't ruled out of the court case. I believe absolutely Judge James Goss should have thrown him out, 100%. But by then they were so far down the line, there'd been so much effort, gone on for so many years, there was so much invested in it, there was just no turning back. It was like a stone rolling down a hill. It couldn't be stopped at that point. Arguably, there's a lot of vested interest involved in Lucy's guilt. And if that's institutional, and then if it's multiple institutions, then it can become a very powerful stone rolling down a very steep hill. And I think as well, it's important to mention that I've said numerous times, I do believe at the start of this process, and they possibly even retain this belief to this day, but I do believe at the start of this process, the consultants were genuinely concerned. And I think the police genuinely believed Lucy to be guilty. And the Crown Prosecution Service, I just don't think are fit for purpose. And I don't think they're capable of assessing whether or not a case should go to court. They're certainly not in any place to assess medical evidence. So there's a lot of vested interest. There's a certain degree of an investment of time. And then I think some of it is systemic and institutional incompetence, whereby they thought she was guilty. Some of those groups, some of those people involved, many of those people involved, believed that Lucy was definitely guilty. And there are clear benefits for her being found guilty. The only person that is damaged by Lucy Letby being guilty is Lucy Letby, whereas if Lucy Letby is not guilty, it's very clear that a lot of people are damaged. So I think it's strong to say they need her to be guilty. That implies a degree of bad faith that I wouldn't necessarily agree with, and that I'm certainly not able to prove. But I think at a certain point there's an institutional investment in what's occurring, and they couldn't turn back. Was the baby unit, a part of it, closed at any time during 2015-16 because of the known leak of contaminated raw sewage seeping through the ceiling tiles of the baby unit, or that the water taps were also contaminated with a bacteriophage which is highly resistant to antibiotics? So there's a very short question to that, very short answer to that question, which is no, it was never closed. It's very clear that they should have taken action on this, but they didn't. When babies A and B were born, there was another very sick baby in the NICU. The registrar had 3 very sick babies to attend to on a weekend. He needed help to put in multiple lines, but Ravi, instead of coming in to help, he literally was telling the registrar over the phone how to insert a line in the baby, talking him through it as if he was giving him directions on how to program an appliance. Ravi at some point finally got his ass in to help. Does anyone know how late it was in the night? So I've researched this and I've tried to answer this question. It's extremely difficult to answer. I don't think it was specifically mentioned. I can't find a reference to it anywhere, and I've looked quite diligently to try and answer this question. So if anyone knows the answer to that question, please do leave in the comments, but I couldn't find an answer to that, and it's possible that it's never been discussed. Hi Chris, I've been following you for a good while now, and I think your content is pure quality. There is one thing in particular I find extremely concerning about Lucy, and I'm unable to shelve it even in the light of strong evidence for her innocence. It's the allegation from parents that she removed oxygen from their child's nose so as to give the dad a picture for Father's Day with a baby. When parents asked Lucy why she removed oxygen, she stated it was normal practice to clean tubes, which they subsequently found to be a blatant lie. that baby would have been struggling to breathe. I wonder what your thoughts are on this. So I investigated this claim. I think what I would say is that with regard to the this is an eyewitness or account testimony that was given by one of the parents in court, I think that there are serious question marks regarding the accuracy of this, but I couldn't actually find this specific claim. I do remember reading about a certain instance where Lucy supposedly removed something so she could take a photograph. I would question whether or not that actually happened, because we know in other instances that there are certain claims made in court, and then when you actually examine those claims, they're not very well founded. So I would question whether she actually did this. It doesn't strike me as very likely that Lucy would remove a tube if a child was in need of oxygen, and then tell the parents, I did it so I could take a picture, and then give inaccurate information. I mean, if she was deliberately harming infants, this would be a major red flag. I just think it's very unlikely to be accurate. Again, if anyone has any thoughts on that in the comments, I'll be interested to read them. Many thanks for something that took a lot of time and effort. I've been hoping for some time that someone would evaluate the conduct of Johnson. If it's perjury for witnesses lying to a court, why does it not apply to everyone, including prosecutors? Shouldn't Johnson be charged with misconduct in public office? So, essentially, barristers, prosecutors, people speaking in court have protection against this, unless there are extraordinary circumstances. There would have to be very, very explicit lies, and there'd have to be very serious lies, and there'd have to be very easily provable lies. Otherwise, the prosecutors and the barristers, there's a lot of protection generally for people in court. I've mentioned several times that Alan Sugar said something about Brian Clough in court that Brian Clough wasn't very happy about, but he couldn't sue him because you can say whatever you want in court and you can't be sued for libel. For example, you have immunity from prosecution. So for barristers, it's even stronger because they're legal professionals. They're there to prosecute the case. So the chances of a barrister would have to do something extraordinary to be charged with misconduct in public office. So that's just not going to happen. I think it's reasonable to be critical of Johnson, but I have been. People in the comments have perhaps been stronger than me. The fact remains he's there to prosecute the case, and he's there to do the best that he can to do that and to achieve a prosecution. Some of what he did doesn't sit very happily with me, and it's important for us to expose that, but I'm not sure that he did anything that would meet the level of misconduct. So there's a similar question here. I could give a deeper answer to this, but maybe show you something with ChatGPT. But ultimately, a barrister would have to make some extraordinarily strongly misleading and false statements to face regulatory scrutiny because they're very strongly protected. I tend to question Goss's mental ability and/or impartiality. Are ageing judges required to take any cognitive tests? Maybe the case was steered to him by the establishment, believing he would be pro-prosecution. So, there's no way. I mean, if they're considered mentally fit, then they won't be required to take cognitive tests. Once they've done the bar exams and once they qualify to be a judge, that's their proof that they have the cognitive ability to oversee a case. I think Goss had a fundamental failing in this case, which is that he didn't understand the case. I'm sure he would say otherwise, but I don't think he did understand it. I certainly think he allowed things to occur that shouldn't have occurred in a fair process. I don't think the problem was his mental ability or failing cognitive faculties. I think the problem was just simply maybe a little bit of complacency and a lack of understanding of what was actually occurring. And it must be said that seemingly many court reporters, the jury, and numerous people have observed the case, certainly through the media and perhaps in court as well in the viewing gallery, have also had similar failings. So I wouldn't be too hard on him for that. But ultimately, it's his job to get things right, of course. I don't think the problem was a cognitive ability or anything that could be measured by a test. I think it was just a lack of understanding of the case and a bit of complacency from having been in court many times previously. Certainly, he will not be required to prove his IQ or his cognitive ability in any way. 2 questions, rather complicated. Answer if you can. The first is the email from Jayaram dated 2017. I think it was May, but please confirm. Would you also give the date of the "we have to pique the interest of the police" email, author, date and time if you know who it was written to, and is the whole email available? I think there is a rather obvious mismatch between the 2 emails written at the same time, but it does need the exact timing of both. So I believe I'm right in saying that this email was written on the 4th of May 2017. It's simply not available. You can see this email, or you can see extracts from this email online, but it's not published by the Thirlwall Inquiry. This is something that's been uncovered by investigative journalism. I don't quite know how it was uncovered, but obviously we've seen it now, so we know that it exists. But I couldn't give you all of the details because they're not in the public domain. But I believe it was published on the 4th of May 2017. Secondly, when was the December 2015 email from the baby unit manager to the hospital management discovered, and by whom? So I wasn't quite sure what you were referring to here. So I'm not able to answer this question. If you recognise this as being your question, if you can clarify the details, or you could leave a comment, then I'll investigate that further. Given how easy it is to attach a series of charges to one individual using propensity evidence and linkage, isn't there a financial advantage for a trust to find a serial killer rather than admit to a slew of medical negligence claims? A serial killer accusation can be used to protect careers or for financial advantage. So the first thing I would say is that undoubtedly there can be a financial benefit to a hospital trust. And indeed, I've mentioned there's this letter from the lawyer Ian Pace where he says the best case scenario for us would be if Lucy Letby was to go for constructive dismissal, because otherwise we could face exactly what you've just mentioned, negligence claims. So yes, undoubtedly there is a potential financial advantage and potential incentive. I must be clear that I don't think that was a motivating factor for the consultants. If anyone would have been motivated to push for that, it would be the executives. It doesn't really make sense for the consultants because they don't really care. They still get paid whatever happens. They don't really directly benefit. It would be someone more in an administrative capacity. So I don't believe that is an issue in this case, and I don't believe anyone was as Machiavellian enough as to decide we'll go for Lucy for that reason. But undoubtedly, the hospital could have faced medical negligence claims. That's undeniable. They don't deny it. It's there in a lawyer statement. Hi Chris, great Q&A, thank you. Another question for next time. We've seen a few accounts crop up lately that drop expert-sounding claims, not to debate but to derail and cast doubt. It seems it's a pattern, no evidence, just pre-scripted talking points, selective facts and misrepresented claims. Do you think there is some narrative seeding going on as part of a coordinated effort to diminish our efforts? So I think maybe there's some minor coordination, but I don't think there is anything major. I think there's just a few people online who are emotionally wedded to the idea that they're right when they're very obviously wrong. But the fact is they'll never be able to get anyone with any credibility to support them. And indeed, they haven't managed to get anyone with any credibility to support them. So they're perfectly entitled to post whatever they want. It's going to have no impact whatsoever on the outcome of this case. The only way it would be if they, as I say, they had numerous credible people supporting them. If they had numerous credible people supporting them, I would pay more attention. If people had come out and said the views of Dr. Evans are credible, or if there had been experts that had tried to buttress the prosecution case, then I would pay attention to that, absolutely. But that hasn't happened, so I don't really pay much attention to what happens on social media platforms. I just do my work and don't look beyond that, really. But if you do see these efforts, then I think it's pretty. I think you can reasonably describe them as amateurish, but I don't think they're anything to worry about, or I certainly don't think there's a deeply coordinated effort. Is there a reason that Myers did not call on Hall for retrial of baby K? It looks to me that not calling Hall was shown not to work and a new plan was required. So it's been expressed that if the case, by Professor Hall, I should say, that if the case had been heard as the defence wanted, which was baby A, both sides, then baby B, both sides, infant by infant by infant, then Professor Hall would have been called. The judge ruled that it had to be all the prosecution, then all the defence trying to defend Lucy Letby. I think the reason for this, it was completely indefensible in my opinion, which was some of the expert witnesses couldn't make it in on certain days, or they couldn't make it in on enough days. So the judge allowed all the prosecution evidence to be heard first. I mean, I think this is almost a dereliction of duty. So that's why Hall wasn't called for any of the cases, because Myers decided strategically that wasn't the right approach. I don't agree with that personally, but obviously he's an experienced KC, so he's done what he believed to be right. But I would tend to agree with you. It's clearly going to help to have expert witnesses in court. I think I've... is this the same question? It's a very similar question about Hall. So this is the retrial now. Yeah, so this is... so the other question is, did he want to make the same mistakes twice? Yeah, I don't think so. I take your point on that. I couldn't give you a good answer to the question as to why he wasn't called in the retrial. I really don't know. It seems to me that it should have been possible to get experts, but as that all came down to Dr. Jayaram and his testimony, and even the prosecution admitted that, maybe experts wouldn't have helped that much. But I feel that the defence could have explained more clearly, a lot more clearly, that extubations happen all the time and there's nothing unusual about it, and they could have got experts to support that, and they could have put a lot of medical evidence in the court to show that, and they didn't. I still think the retrial could easily have gone against Lucy because it was so chronically unfair. You could hardly say it was a fair trial. I don't see how anyone could possibly claim that it was a fair trial, but whether Professor Hall would have made a difference, I'm not sure. If the reason for Goss not to throw Evans out was because the case would collapse, could that be considered contempt of court? So Goss is the presiding judge in this case. That gives him an enormous amount of power, an enormous amount of authority. It's almost impossible, again, for him to be considered to be in contempt of court. What he says goes, essentially. So unless he makes some massive legal error, he's entitled to do whatever he wants. As I've said previously, I absolutely believe that Dr. Evans should have been thrown out of this court case when the letter was sent from Jackson to Goss. The fact is it wasn't. I assume that is legally allowed to happen because it did happen, and therefore it's not contempt of court. Hi Chris, another couple of questions. Could Myers not have brought up in his cross-examination of statements, 1, the letter showing Evans was an unreliable witness, 2, the RCPCH report? Would Judge Goss have interrupted him and told him to shut up, strike from the record, tell jurors to disregard, etc.? So this is a question that I can actually answer definitively. The first thing is that Myers did bring up the letter regarding Evans being an unreliable witness, and he did actually mention some specific aspects of that during his cross-examination of Evans, and he was quite strong on that, to be fair, and rightly so. And I think Myers will know. I'm sure he's sitting there now, and I'm sure he will still think about the Lucy Letby case. I'm sure he will know that Evans should have been thrown out of the court. With regards to the RCPCH report, obviously the defence wanted this to be in the court case, and the judge ruled that it couldn't be in the court case. So it would be extraordinarily bad practice for the defence barrister to bring that up. And if he had done so, Judge Goss would have indeed interrupted him. There could have been all kinds of... It certainly would have been struck from the record, but there could have been further consequences. He could have been replaced as a barrister. Who knows what would have happened exactly? but you just don't go against the judge like that. It's bad practice. You don't want to annoy the judge. You want the judge on your side. So if the judge says don't reference the RCPCH report, you don't say, oh, let's have a look at the RCPCH report. That's the worst thing you can do. While I really appreciate Justice Jackson informing Judge Goss regarding Evans' expert witness suitability, could he not have informed the Lord Chief Justice and others so that he could be placed on a barred list, duty of care, etc.? So the short answer to that question is yes. He could have informed other groups or other organisations or other prominent people before the court case took place. But as I've said previously, we don't know when Judge Jackson, Lord Justice Jackson, became aware of the involvement of Evans in the court case. So he may have done it at the first possible opportunity. The other thing is that it should be mentioned and it should be noted that it's already a big intervention for a judge to write to another judge. And he may have thought this is the most appropriate and most effective way for me to do this. And I'm sure he thought long and hard about whether or not he was going to do it, because it's not something that happens every day. So I think Lord Justice Jackson actually deserves a good deal of credit for highlighting this and acting in a way that was, moral and ethically upstanding. Because he didn't have to do anything. He could have just... I don't know too much about his background. It's not really been necessary for me to research it, but he's part of the judiciary. He doesn't have to do this. He doesn't have to get involved. He can leave Judge Goss to adjudicate the case and oversee the case on his own merit, in his own way. And I do think he should be applauded for doing that. Yes, possibly he could have done other things, but as I say, we don't know the full details, so I wouldn't wish to be critical. I mean, I'm glad that he did what he did, even though, I believe Goss made the wrong decision. Was it addressed in court or at any point by the COC occupational therapist that the notes were thoughts Lucy had written down after being advised to? It's quite clear what the notes are, the internal anguish of someone being accused of such crimes. However, I would like to think that in court the occupational therapist gave evidence that she did advise Lucy to write these notes, as it would disprove the prosecution's argument that they are a confession. So there are a few things to mention here. The first thing is Kathryn de Bager did not give evidence in court. She was not called by the defence. She obviously wouldn't be called by the prosecution. The second thing is that she's never spoken about publicly about this advice that she'd given to Lucy about the notes having been written down. However, I know for a fact that it's true. I can't tell you how I know that it's true, but I know for a fact that it's true. Hi Chris, thank you for your info on Dr. A. Afraid I have another stupid question. I'm sure it's not stupid. I don't know if this is true or not, but when Lucy was sentenced, apparently her mum was shouting and said to take her instead. If true, I would think it's because her mum was wanting to protect her but not sure. Are you able to look into this or give an opinion? Thank you again. And in case no one said this, you're doing an amazing job with this and you should be proud of yourself. Thank you very much. Firstly, it's absolutely true. That is exactly what Lucy's mum said. It's become clear to me from speaking to a few people that Lucy was very much a treasured daughter. I think that's clear anyway. I'm sure you've seen the notice in the local paper when she passes her degree course. They really were proud of her and they really treasured her. She's an only child, so that probably amplifies things further still. So her mum was obviously hurting very, very much when Lucy was convicted, as any mother would be. And she did say that. And the last thing she wanted to see was for her daughter to go to prison. And, her parents are living in a horrible situation. And anything that I'm doing for them as much as for Lucy, because I'm sure Lucy's going through a very difficult time. We've heard that she is. However, she will adapt. She will find ways to adapt. Her parents are serving an awful prison sentence where, what can they do? What can they do? They can't influence anything. They're watching their daughter suffering. Their daughter was suffering when she was just taken off the unit. There's a letter in the Thirlwall inquiry where they indicate that. So I feel so sorry for them. I wish I could do something to help them. I don't think anyone can help them. All I can do is try to help with Lucy's case. And that's what I'll continue to do. Didn't they, this means the Countess of Chester, get an upgrade to treat more severe younger babies just before Lucy Letby joined, and downgraded not to treat as young babies when these deaths came to light? Hence the drop in deaths just by they're not being allowed to treat those severe cases. So it's absolutely true that they were downgraded literally when Lucy was moved off the unit. So that is clearly a very significant factor in what has occurred. In terms of them getting an upgrade, it wasn't... Yeah, so I believe I'm right in saying it was fairly shortly before Lucy joined. It wasn't just before the 2015-2016 period, it was before then. But Lucy had been a nurse before then. It's not as if she just arrived on the neonatal unit. So I think it did roughly coincide. And there have been question marks because Lucy worked in this unit for years before there were any issues. And obviously it's been asked, why did she suddenly start attempting to harm babies when she'd been worked as a nurse previously with no problems? Now, I suppose people have tried to muddy the waters. Dr. Stephen Brewery said during Thirlwall she probably harmed babies before this date, even though he's got absolutely no evidence for that. Of course, he had no evidence for what was sent to the police, as we know. And I suppose further muddying the waters with these Liverpool cases. In reality, there's no evidence that Lucy Letby was anything other than a dedicated nurse prior to this period, and of course, we strongly believe that she's innocent of these allegations. So it is interesting, illogical really, that she would just suddenly begin harming babies. And I think these are both valid observations that are made in this question. Why does an experienced judge need an expert on the confession note when he can just read out the incriminatory bits? So that's an interesting question. The judge obviously is there to preside over the case. So what could theoretically happen, this is obviously very unlikely to happen, is that the prosecution could say, oh, look at this confession note, and then the defence could say, we don't wish to question the confession note at all. And then the judge would just reflect on that when summing up and just give an account of what occurred in court. It's not really the judge's role to need an expert as such, but the judge would interpret what the expert told the court, just as the judge interprets the supposedly incriminatory aspects of these notes. An expert was really needed, in my view, to discredit these notes from a defence perspective. It's very obvious that they're not confession notes. I mean, anyone with two brain cells to rub together knows that they're not a confession, and they should never be taken that way. How anyone could possibly believe that they were, I have no idea. But that would have been where an expert could have come in useful, and I believe the court should have heard from an expert, and I don't know why the defence didn't enlist an expert. But it's not really so much for the judge, it's more for the court, and then the judge would interpret that in summing up. Only one of the arrests was videoed, showing Lucy being marched out of her house in handcuffs. It has been suggested the old Bill kicked in the front door of her parents' home in one of the arrests. Is there any truth in this to the best of your knowledge? So I just want to mention one thing. The reason that Lucy is arrested from her parents' house is because she was barred from the county of Cheshire after her first arrest. That's why she's not arrested from her house the second or third time. In terms of whether there's any truth of the front door being kicked in, I've absolutely no idea. It seems to me that this is speculative. It's the kind of thing that could have started as a rumour and has been amplified by the internet. I'm quite doubtful, actually, that the front door was kicked in, because I think Lucy and her parents would have just answered the door. Right, sorry about the interruption to Kiko there. She was just having a very noisy sleep. Yeah, I'm very doubtful that the police would have kicked in the front door, because they usually only do that if they believe that a suspect will be resistant. I think it's quite likely they would have banged on the door, Lucy would have come to the door, her parents would have come to the door. I don't think they would have just kicked the door in, but I have seen them do this type of thing, so it's not out of the question. But usually it's because someone... I saw it... I don't know about you... The guy who is ultimately gone to prison for the kidnap of the supposed planned kidnap of some celebrity. I can't remember who it was now. They banged his door down, but it was to prevent him from destroying evidence. Now, I know the police think they've got evidence from Lucy's house and Lucy's parents' house, but I mean, come on, it's clearly not of central importance to the case. So I don't think that would be true, but I can't say definitively that it's not true, and there is a chance that it could be true. Is this the greatest ever perversion of the course of justice the world has ever witnessed? Probably not, given that everything that has ever happened in the world over thousands of years. Probably not. I also have to say I'm not an expert on all criminal justice systems from every country. So I would say probably not. I'm sure there have been worse cases in some countries. As much as we're critical of some things that occur in Britain, there obviously are some very unreliable nations in the world. I think it would be... This term greatest is a value judgment, of course, and there's many different ways to assess whether or not something is the greatest miscarriage of justice. What I would say is, this was such a high-profile case. Lucy's facing the stiffest penal sentence a woman has ever faced in Britain since the abolition of the death penalty. It's obviously a very, very contentious, serious crime, if true. And then there were doubts so quickly, and those doubts had now become so overwhelming with such enormous public support that there's no doubt this will be written into British history for centuries to come. And in that sense, it is an enormous miscarriage of justice and the greatest perversion of the course of justice, as you describe it. I mean, technically, it's not a perversion of the course of justice because that's a different thing entirely. If you pervert the course of justice, it means you deliberately interfere with court proceedings. But I know what you meant. It probably isn't, in legal terms, in terms of a miscarriage of justice, it probably isn't the greatest ever. But, you know, if you were doing a countdown the top 10, it would be up there, I'm sure. Great interview as usual with an excellent expert in his field. I'm interested in transparency and would like to know how much compensation has been paid out to individual cases and the reasons for culpability. How available is this data, and can payments be made to claimants subject to gagging clauses so some of the relevant information can be hidden from public view? So it's difficult for me to answer this question fully, but I'm going to show you my investigation of this matter. So the answer to the first question, as you might expect, is sometimes but messy. So I can tell you from my personal experience that information about individual hospitals can be very difficult to get. You always have these questions about what were the figures for the Countess of Chester in various years, and it's just simply not published. The only reason it's published with this is because there's a court case, and then you get asked about the non-indictment infants, and that's all censored. So while I've been doing research, it's been difficult to get hold of certain things. And then on top of that, we have these things called freedom of information requests, but it seems that people can just say, we don't want to answer the freedom of information request, which would kind of beg the question of how free is that information? But yeah, it's possible to get hold of some of these things. There's court judgments, public body FOI, disclosure logs, some information from regulatory licensing bodies, and then here's some reasons why you'll hit gaps. Confidential settlements and NDAs are common, so nothing overrides that because it's a legal settlement. You can't just say, well, it's a freedom of information request. You just run to a brick wall. Privacy laws block releasing personal health information. FOI regimes and privacy laws generally prevent releasing identifiable patient records. National databases may not be publicly queryable. Records are fragmented. Another reason I'll just add to this list is sometimes organisations and institutions just don't want to give you the information, and you can't make them unless you're powerful. And you can send them all the FOI requests you want. They will find some reason not to send you the information, as we know. So there are several reasons for you. And then just simply, there's some further information here, but yes, these are practical steps you can take, but if they don't want to publish the information, they won't. And I just simply ask this question: can payments be made to claimants in the above scenario be subject to gagging clauses so some of the relevant information can be hidden from public view? Yes. Settlement payments in medical negligence or malpractice cases can be tied to confidentiality clauses, often called non-disclosure agreements. There's some more details about this, that it happens routinely in Britain, the United States and Europe, and the settlement amount, the narrative of what occurred, the identities and the hospital admissions or liability can all be kept from public view. So once you've taken away the settlement amount, the narrative of what happened, the identities, and the hospital's admission and liability, I'd like to know what is left of any relevance. And this is kind of answered here: court judgments, statutory mandatory reporting, and freedom of information. But if you're not free to release any of this information, I'd like to know what you are free to release. So basically, yes, a lot of this can be hidden, is the short answer to the question. So the following question is a very deep question. Chris, do you think UK institutions will deal with this nightmare? Or is this case and its implications too big to deal with? Hopefully, with many prominent experts like your guest speaking out, it cannot be swept under the carpet. Do you think the case has become so big that UK institutions cannot avoid dealing with its massive mistakes? Very good question. As I've discussed previously, if there's one thing we're good at in this country, is brushing things under the carpet. There's always, Stephen Phelps was talking about this as well, but there's always a desire for us to say, oh, we're great at this, we're the best in the world, we don't need to change anything. And that has meant over decades that we've declined, and now we're not really the best in the world anymore. And then I think also on top of that, there's always an institutional feeling of, well, this is too difficult to deal with. We've got a system. The system is working. Let's just, as is mentioned here, sweep everything under the carpet. When Lucy is exonerated, there will be an enormous amount of fallout. And I think in answer to your second question, its implications are too big not to deal with. There'll have to be some response. Now, we know whitewashing is another thing that we're great at in this country. So there could be some attempt to do that, of course. I think it's going to be imperative and incumbent on us to ensure that this is properly addressed, there's proper reform, and that this leads to systemic change. I'm sure Sir David Davis will be a big voice in that. Hopefully there'll be other big voices, and I will have a small voice, and I will try to use my voice where I can. I do think ultimately the case is too big for the institutions to avoid dealing with its fallout, because there are so many problems, so many very obvious systemic issues. I think for them to just simply say, oh, well, that was a bit of a cock-up, never mind, we'll just carry on. I mean, when this is overturned, this is going to be almost, in its magnitude, it will be as big as something like Brexit. Of course, it won't go on for as long as Brexit, but it will be of that magnitude. It will be headline news on it'll be front page of every newspaper, headline news on every TV station. It'll be in the news all day, it'll be in the news the next day, it'll be in the news the day after that, and it'll be referred to with some frequency in the weeks that follow. So there will be no brushing this under the carpet, in my view. One thing I will say that is perhaps slightly concerning is that gives a good motivation for an appeal to be refused, of course, which is why it's critically important for us to continue to expose this, continue to pile the pressure on, and make sure that public opinion is strongly behind this being a miscarriage of justice and that a retrial being necessary. So this is a similar question. What happens after Lucy Letby is exonerated? Exoneration surely must come with an acknowledgement of the dubious roles others played in Nurse Letby's bogus trial. So then there are numerous follow-up questions, so I'll go through these one after one. What happens to Evans after the truth is laid bare on the Letby case? So the first thing to say is there's no guarantee that he'll be alive. If he is alive, then he's going to face serious consequences because he's the most vulnerable person. Indeed, it's important for us to ensure that he's not scapegoated and all of the institutions are allowed to hand wave what's happened and blame him. Of course, he needs to take a portion of the blame, but not all of the blame. What happens to a legal system that authorises such a biased, incompetent and wholly unsuitable individual to be the principal expert witness in one of the most serious and dreadful trials in British criminal history? So the first thing is that the Law Commission recommendations from 2011 will need to be enacted. That's the bare minimum requirement. There needs to be a very serious scrutiny of how expert witnesses are selected for the court system, and ideally that needs to be reformed. Those would be like the two bare minimum requirements, but I think a broader root and branch reform should certainly be considered. It goes without saying there'll be an inquiry. There'll have to be an inquiry into the Thirlwall inquiry. That goes without saying. What happens to Cheshire police? Usually the police weasel their way out of everything. I hope that they face some institutional scrutiny. I hope they don't just say, "Oh, soz Lucy, that was a bit of a cock-up. Anyway, we're the police, we'll just carry on what we're doing before." But you've seen what happened with the Hillsborough inquiry. The police usually weasel their way out of any situation. So the ultimate answer to your question may be nothing whatsoever happens to the police. It's clear that there needs to be a very serious examination of how the police investigate cases and whether they're capable of investigating these very complex cases. And I say that more broadly about the police as an institution, not just Cheshire Police, but the police as a whole. But obviously Cheshire Police should face some scrutiny. Whether they will, I don't know. What happens to Goss? So nothing will happen because in the eyes of the law he hasn't done anything wrong, and also he's another one who's not guaranteed to be alive. What happens to the CCRC for their painfully long delay in action? So the CCRC are actually dealing with this case relatively quickly by their standards. The CCRC has been criticised, and rightfully so. I do think that they are taking action to try and address address these criticisms and reform the organisation from within. So let's just wait and see what they do. I know people want this to be referred. I know people want this to be referred quickly. It is kind of a glacially slow system at times. Lucy's being dealt with relatively quickly, and I guess we should be grateful for that. I think if the CCRC refers the case and refers it by next year, then we shouldn't be too critical. A much bigger concern for me has always been the Court of Appeal, and we'll just have to see what occurs there. But the CCRC will be constantly being reviewed now because they've been very publicly criticised, and rightfully so. So I think they'll remain under review. In terms of what will happen to them, the fact is that this won't be seen as a painfully long delay. It will be seen as a relatively quick decision. What happens to Thirlwall? For ploughing on with the tribunal, she was publicly urged to postpone, and by doing so earned a substantial fee for herself and incurred millions of pounds in other costs, mainly lawyers' fees at the expense of the British public. So there will be an inquiry into the Thirlwall inquiry. I have someone who I respect very much, who is a very experienced person, has said this to me. Thirlwall herself will largely escape censure because essentially she's doing what she's told. She was told to run this inquiry. She was told how to run this inquiry. She told the inquiry what her fee was. They agreed the fee. So she hasn't done anything wrong, essentially. It'll be very interesting to see what happens in April, but I doubt anything will happen to Lady Thirlwall. She'll just be patted on the back, no doubt, and probably receive a civic award of some sort. What happens to Moritz for her failure to apply proper journalistic standards and cashing in on her biased coverage? I would say absolutely nothing, because the BBC have shown no seriousness whatsoever to the chronic bias that she and the organisation have shown, the corporation have shown in the covering of the Lucy Letby case. So they will say, we did apply proper journalistic standards, we've already defended Judith and she has no case to answer. What will be a bit sickening would be, and this could happen, would be if Judith tries to claim credit and say, oh, I was there from the start and now here I am reporting on the overturning of this case, when she's obviously been very pro-guilt, in my estimation. But nothing will ultimately happen to her. She might not even be working for the BBC. She might be like Susanna Reid and jump ship by then. But we don't know for sure. But I doubt she'll face any consequences at all. What happens to the consultants who not only stitched up Nurse Letby to cover their own hides, but then failed to right their wrongs at any point along the way? So they are far more likely to face scrutiny. Because they have each other and because they could be backed up by the trust and by unions, etc., etc., it's very hard to say what will happen to them, but it's very clear that there would be an investigation into what occurred at the hospital. What happens to the NHS, which must surely admit negligence and culpability for many deaths that were previously ascribed to Nurse Lucy Letby? So one would hope that, considering the institutional issues that are inherent in this case, that there would be some sort of assessment, analysis or examination of the NHS, and that I don't think the institution as a whole would accept negligence and culpability, nor should it, but I think it should be acknowledged that there are genuine cultural problems in the NHS and that these must be addressed, and that only when these are addressed will the standards of the NHS improve. One would hope that would happen. Whether it actually will, I wouldn't like to make a prediction on. And then finally, what happens to Ben Geen, Colin Campbell and Beverly Allett and any other medical professionals convicted on similar charges? So this could help them. What I will say in the case of Beverly Allett is that she has confessed, and regardless of the legitimacy of that confession, it wasn't a false confession in terms of being extracted from her unfairly, so it's going to be unbelievably difficult for her to ever overturn a conviction. Colin Norris / Colin Campbell has a better shot, given there are similarities with Lucy's case. I don't know as much about Ben Geen's case. I know people believe him to be innocent. I know Mark MacDonald believes him to be innocent. It would clearly help him if Lucy was exonerated, but it's not as if it will automatically open the door, but it could have positive consequences for nurses that have been wrongly convicted. Could Dewi Evans be sectioned under the Mental Health Act by a GP? Well, anyone can be sectioned under the Mental Health Act if it's appropriate. I believe that Dewi Evans is compos mentis. I discussed this in the video where I examined his contributions to the Channel 4 documentary, and I mentioned that Svilena Dimitrova has been raising certain things, and her views should certainly be respected. I believe that he's compos mentis, and in order to demonstrate this, I'd like to reference the novel Catch-22, which is my favourite novel. You may have read it, some people may have read it, and there's also a film. And the premise of Catch-22 is that it's set in the Second World War on an Air Force base, and the central character really wants to get out of combat duty because he doesn't want to die, basically. And there's a ruling on the Air Force base that if you're crazy, if you're considered mentally unstable, you can get out of combat duty. But in order to get out of combat duty, the only thing you have to do is ask to be relieved of your duty. And then as soon as you ask, then you're not crazy, because no one who's crazy wants to get out of combat duty. So essentially, Catch-22 is this scenario where you can't get out of combat duty, whether you're crazy or not. But the act, in that scenario, the act of asking, can I be relieved from combat duty, I'm crazy, is an act of self-preservation. And that is what I see with Dr. Evans. I see him engaging in lots of acts that are acts of self-preservation. And people that have, serious mental health conditions don't act in that way, because that's a rational impulse to act in a manner of self-preservation. So my view is that there's absolutely nothing wrong with him, apart from the issues that we've discussed. It seems at this point in this previous video, Dr. Gibbs believed the air embolism theory and really believes that it solved the mystery. Was it Evans who introduced the air embolism theory originally? Do we know for sure? No, it wasn't. He obviously pushed it very, very hard, but it was mentioned, I believe, by Jayaram first. Certainly it was mentioned by consultants, and Jayaram definitely mentioned it. I believe he was the first person to reference it. Dr. Evans was certainly not the first person to mention this in the case as a whole. He claims that he was. He will always say, I was the first person to mention this as far as I know. And it's that expression, as far as I know, which suggests to me that there could be more to this than meets the eye. But as I can't prove that, I don't know. But no, he wasn't the first person to introduce this. How many neonatologist experts and statistical experts are required anywhere in the process to give enough evidence beyond reasonable doubt to convict a caring, exemplary, well-motivated and increasingly accomplished trained nurse of 7 counts of murder, 7 or so counts of attempted murder by 6 different methods of inflicted harm on an overstretched, failing, filthy ward, accepting babies who were doomed according to independent risk assessments and with massive problems outlined by a medical Royal College report, without a single eyewitness indicating any inflicted harm, occurring in a British High Court and confirmed in a retrial by the same judge and denied a right of appeal, despite 26 world experts, neonatologists, saying in effect the whole thing was a fabrication. So you would think, as you rightly point out, that this would result in an almost automatic exoneration. I think a lot of the attitude of the system is a kind of high-handed desire for the system to always be seen as right or always be seen as credible. So things are never overturned too quickly, particularly a case of this magnitude, because they just want to say, oh, it's a lot more complicated than you think it is, and, oh, our court case wasn't as bad as you think it was, and so forth. So objectively, based on what you stated here, yes, Lucy would already be free, but we just need to keep pushing and do everything we can to expose, as you rightly point out how ridiculous the situation is. Another good video, Chris. A question for a future one. Was Nurse Lucy ever evaluated by a forensic psychiatrist? So I'll just answer that question first. She must have been psychologically evaluated. And I can't remember if I've ever seen this being confirmed explicitly, but basically, certainly, once she's in prison, she will be, and that should happen. The police have a duty of care. I don't believe that they have fully met that duty of care, but they do have a duty of care, and they did have interviews with her, and they will have had her psychologically analysed, because otherwise they're not meeting their basic requirements for duty of care. So then there's some more comments about the Australian legal system, and then there are questions about it seems to me the prosecution made many claims about Lucy. She was devious, cunning, a liar, insinuated MBP, yet it seems they did not pursue a psychiatric report. Why not? Are they asking her to see one now? So they definitely won't ask her to see one now because they've convicted her, so they've done their job. Even if they hadn't convicted her, they still would have done their job. In terms of why they didn't pursue this at the time, the simple reason is they could have got an answer they didn't want. Then they just would have had to jettison it. So they probably knew that there was no psychological or psychiatric basis for anything that they were saying, and they just realised, well, we'll just say it anyway. We're barristers in a court. We know how to convince people. We'll do that. We don't need an expert, because an expert will say what we're saying has no foundation. You'd surely expect that the consultants would have significantly increased their presence on the unit amidst the increase in deaths, especially if they suspected deliberate harm. How could they not consider that only 2 ward rounds a week was acceptable? So I actually read something that Susie Holt said in the Thirlwall inquiry the other day. Eventually I'm going to do a video on Susie Holt, because I have neglected to really talk about her at all, and even downplayed her involvement. Her involvement is not huge, but there are some significant things that I need to mention. So at some point in the foreseeable future, I'll do a dedicated video about Susie Holt. But essentially, she acknowledged in the Thirlwall inquiry, she didn't have a lot of choice because it's documented, but she acknowledged that they were only doing 2 ward rounds a week, and she seemed to suggest that they had since increased that. It's an interesting point that you say they could have increased their presence because they suspected deliberate harm. It's actually a very, very good point that they didn't do that, which is as you rightly assert, hard to understand. It's hard to understand how they didn't know that this would be a basic requirement of a neonatal unit, level 2 neonatal unit. Their presence was essential, even though they have made numerous medical errors. there are observational errors, there are monitoring errors, there are errors in medical procedure, and so on. So it's not as if they were perfect doctors necessarily. Some of these procedures are being conducted by registrars as well. Perhaps nurses are involved at times, but it's clear that they weren't infallible. Of course, no one is, but I mean there were major errors made on this unit, but certainly their presence was required. So how they didn't recognise that and how they've allowed such a poor level of service, one can only imagine, because there is no justifiable explanation for this based on what I've heard. I mean, this is numerous medics, numerous doctors, numerous nurses all telling me, I mean, 2 ward rounds a week is tantamount to negligence, essentially. So I can't answer your question. I have no idea. There is no good answer to your question. I was just thinking that the 2 insulin cases are the most important ones to be thrown out because of how it led the jurors to make decisions on other cases. It has been said in legal procedure that if some experts' opinions challenge other experts, it is just a difference of opinion. But what Walker and Milan stated in court can be proven to be factually wrong. So actually, I'll just continue. Just 2 of the things they said. Testing of blood samples was said to have been running smoothly without mentioning the nearly 800% exaggeration incident. No further testing was needed to show exogenous insulin was used, just from an immunoassay, which we know is false. So we know this is not a matter of opinion that could be used against Lucy. We can say this is new evidence. And also, with regard to the 800% test exaggeration, nobody else could have revealed this apart from Walk, and she chose not to, so it can't go against Lucy that this should have been brought up at trial. So these are all interesting points. I do agree that I think it's undeniable that the insulin cases are important. Of course, it's worth noting, one of the important aspects of the insulin case is that can be overlooked, although people are generally aware of this. But it's critically important that the infants didn't die. So in the Colin Norris appeal, for example, there's a higher bar of entry in a way because all of the patients died, and one of them that died, Ethel Hull, proved to be centrally important. In this case, you're talking about tiny little babies supposedly being given very high doses of insulin and yet not dying. So that would be very unlikely and very strange. That's very curious in itself. So the fact that they didn't die means that there should certainly be a lower barrier of entry to overturning these cases. And I know that there will be a focus in the Court of Appeal on the cases in which Lucy was convicted of murder and where people died, because in the cases of attempted murder, they can fall away very quickly if the murder cases are disproved and they collapse. So I totally agree with you, the insulin cases are important, but they're not necessarily more important than the murder cases. In terms of experts giving categorically incorrect statements, you're absolutely right. And I think the Court of Appeal are going to have a very hard time in this case saying, oh, well, you could have said this a few years ago. Because firstly, there's new research that is undoubtedly fresh evidence. And then secondly, it would be extraordinary, given the level of expertise, given the level of media coverage, given the fact that the Court of Appeal know the eyes of the world are going to be on them. And by the time it happens, that'll be much bigger than it is now, rest assured. So for them to just say, oh, well, that's great. Thanks for all your expertise. Thanks for your 29 experts. There'll probably be more than 29. There's 29 now. Thanks for all your evidence. Thanks for, your very deep concerns about how serious this matter is and how serious it is for the healthcare system. But we're just going to ignore all of that because you could have said it 3 years ago. They're going to look so ridiculous if they do that, and they're going to be hammered by the press. Their verdict, their verdict that they publish, that'll be on the judiciary website. This Court of Appeal verdict is going to be poured over by many people. By many people in the legal industry, the legal trade, the legal niche, however you want to describe it, by many doctors, by many medics, by all of the panel, by people all over the world, by media, by television. Everyone is going to go through this verdict with a fine-tooth comb. So if they say, oh, well, yeah, that's great, but you just could have said this a few years ago, they're going to look monumental. They're going to get an absolute hammering. So they will be aware of that. And if they're going to turn away this appeal, they're going to have to come up with something pretty strong, very strong, if they're not going to receive absolutely stinging criticism. And bear in mind, they were already criticised for not dealing with Tom Hayes' case correctly. So Tom Hayes, whose conviction was overturned by the Supreme Court, they were criticised in relation to that. The CCRC has been strongly criticised. There have been numerous miscarriages of justice recently. They've been exposed. They've dragged on for decades, and the people have turned out to be completely innocent. So they're going to be under enormous pressure, rest assured, and it's not going to be easy for them to just say, oh, well, we're just using our policy and procedure. Thanks very much. Lucy stays in prison. And if they do, there's going to be enormous backlash against them. And I'll do everything that I can to make sure that they're under more pressure than they are now. And there's just a little follow-up question here. There is obviously so much more that can be said, but just these two things alone look very good for Lucy because of the implication these two cases had on the others. Do you agree? So I know for a fact there's been a lot of effort that's gone into the insulin submission, and I met Helen Shannon briefly, and I know both her and Jeff Chase are absolute experts in what they do, and they've had incredible results in their field, and there is fresh evidence. And I think, based on what you said, which are very, very good points, hopefully things will work out well. I can never be 100% certain because the Court of Appeal has done so many ridiculous things over the years, but I'm hopeful that they will see something needs to be done in this case. Can you clarify re Baby K? Michelle said that Lucy took over Nurse Williams' baby when Baby K came into Unit 1 with Nurse Williams. So Lucy had 3 babies, not the 2 reported. Where was the third baby placed? Was it in Unit 2 or Unit 1? Nurse Oakley had 2 babies in Unit 1. Nurse Williams had Baby K. That leaves 1 spare cot in Unit 1. That means Lucy has 3 in Unit 2. This makes it even less likely that Dr. Jayaram saw her in Unit 1 doing nothing. I believe that Dr. Jayaram actually saw Oakley waiting for him, not Lucy. This clashes with his email, but he was mentally in a mess. So I'll just stop at this point and just spread this out a little bit. So firstly, based on my observations, on my research, on people that I've spoken to, including people that know Caroline Oakley, it's very likely that Dr. Jayaram did not see Lucy. Your other comments about the babies in the units, I'm not sure about this comment that there were 3 babies, not the 2 reported. I mean, this does get quite complicated, this question. I'm not 100% sure, but I think the third baby was in Unit 2. The whole point is that Lucy was in a separate unit, and I believe that it's Unit 2. Of course, there's 3 nurseries, so it could be Nursery 3, but I believe that it was Nursery 2. I think I'm correct in saying that. It could be Nursery 3, but the point is that Lucy's not even in the room. Lucy's not even in Unit 1 at all. At the time that Dr. Jayaram comes in, she's very likely to be in another unit. And the timing all matches with that, as you point out. I understand that Dr. Jayaram had been called out having already worked all day. We will probably never know what really happened with Baby K. There are so many questions. Lucy was in Unit 2. Now Unit 2 is on the other side of the corridor, correct? So it's important to point out there's a dividing line and a dividing door between Unit 1 and then Unit 2 and Unit 3 are next to each other on the other side of the dividing line. The other side of the corridor, as it's stated here. And the nurse's station, as this poster rightly points out, is right outside Nursery 2. Where Dr. Jayaram was phoning and making notes to get to Unit 1, Lucy would have to walk right next to Dr. Jayaram. Absolutely. So this is another major problem with the whole theory. Also, Unit 2 has a big window, so Lucy could be seen working from the nurse's station. The case for Baby K is complete nonsense, correct. the panel said there was no record of displaced tubing, only undersized tubing with 94% leakage. It was at this time that the panel said he did not know what he was doing. How overworked was he this night? This suggests staff shortages. Staff were being put on duty when not fit for duty. I agree. It's clear that they were understaffed. That there's countless evidence pointing to that. And he obviously would have been tired at this time. And they've made some major mistakes with the leakage, as you rightly point out. You will have seen a video on Child K recently that I've recorded, which discusses this 94% leakage issue that is pretty serious, obviously. Remember, the judge did not accept the report saying there was a staff shortage did not affect the cases. The man was an idiot. The judge and prosecution kept thinking these deaths were events. This was not so the baby's health was a continuum of events, often starting in the womb. Thinking in this way, not murder on its head, but that is what was happening. Again, the judge and prosecution made much of the assigned baby, but nurses are not islands. They have their own babies, but do not work in isolation. They are a team. They work together and help each other. So these are all fair comments. It's very true that the RCPCH report that you referred to should be in the case. I've mentioned that countless times. Again, there's just no justification for excluding that from the court case. It's preposterous. It's just a major mistake. I agree with what you're saying about the nurses. I think it's just very clear in this case that Lucy wasn't really in this unit, and that Dr. Jayaram and his Swiss cheese memory has made another mistake. He's made numerous mistakes. He's frankly fortunate that the police won't ever investigate this, given that we know he made other statements in the email that completely contradict what he said in court. Under normal circumstances, that will be investigated. Because the Cheshire Police are so invested in their current position, I'm extremely doubtful they will investigate it. And put it this way, I'm doubtful we'll ever hear anything about it. They have to look at the situation, seeing as a very senior MP has asked them to investigate. But I suppose ultimately they don't have to do an investigation. If they decide that they don't want to and they don't think it's justified, then they don't have to. And we'll never hear anything about it. But I don't for one second think we will ever hear anything about that case. The judge does come across as extremely biased. One defence I have heard when suggesting that this is a miscarriage of justice is that juries are well instructed. Some may be, but I think the instruction in this case was extremely unbalanced. So I don't wish to suggest the judge was biased. I'm sure he did the best that he could. I know some people have said otherwise in the comments, and you're absolutely free to express those views. I would not wish to make that accusation, and I will assume that he did the best that he could and acted in good faith. I agree that every single decision in this case from the judge went against Lucy. With regard to the instruction of the jury, I think people generally completely overestimate the abilities of the jury, and also think that if they're, in this particular instance, or with regards to this particular issue, just because the juries are instructed to do something doesn't mean they can actually do it. One thing that has to be recognised, I'm going to be answering a question about this later, or related to this. You have to understand that no one is entirely objective. It is impossible to be completely objective because we're not in contact with our own subconscious mind, for example. So there is no, when people claim to be objective, I don't know how many people do, but any thinking person knows that everyone is subjective to a certain extent. So just having someone tell you, right, I'm informing you how you're supposed to judge this case, now go ahead and judge it that way. If that person was a Vulcan, if it was Spock, I know he's half Vulcan, half human, but if this person was a Vulcan, they could just say, right, I will now sit down and rationally assess this case. But unfortunately, we're human beings with emotions and all kinds of prejudices and various aspects of confirmation bias and other judgment errors and attribution errors and such like, cognitive biases. So just because we're told you must you must assess the case this way doesn't mean that it's going to happen. So with regard to Child K and the retrial, why do you think Johnson is sitting there going, Lucy's a murderer, Lucy's a murderer, Lucy's a murderer, and the judge is going, just ignore Nick Johnson saying Lucy's a murderer over and over again. What good do you think that did for the jury? We basically know it did no good because they decided in a very short period of time that Lucy was guilty. So I think judges' instructions are completely overrated, frankly. On an incidental tangent, the theme of trust in the courts is fascinating to me. I'm someone who believes government is necessary, but I have a pet idea that government is never rational, nor are attempts at rational government desirable or generally successful. I'd say in the modern day, representative democracy is seen as the natural form of government, but if you scratch below the surface, the idea that everyone should have an equal vote is a metaphysical assumption with no basis in reality. I'm not even saying it's a good or bad idea, but everyone over 18 deserves a vote isn't really logically deducible from anything self-evident, no more so than the divine right of kings or mandate of heaven or whatever. While I realise this was long-winded, my point is that I think a lot of people have genuine cognitive dissonance over the idea that a jury is just 12 ordinary people. I'm sure they could have all the evidence properly presented and still get things wrong occasionally. And that's before you get to all the other pitfalls. So I've just essentially expressed the same view. So I absolutely agree with you. I think you've picked a very interesting way of expressing this. I must say, personally for me, I personally favour direct democracy over representative democracy, as occurs in Switzerland. Maybe one day I'll make a video about that, but it will be a long, long time in the future. But I think if people have a direct stake in government and in the political process, they will be more active and they'll be more politically aware and they'll be more informed. So I would like to see, and there are pitfalls with this, because if you don't have an educated population, if you don't have an informed population, then there are obvious problems that can occur. But I would love to see a situation where you can, as in Switzerland, you can raise a petition on any issue. If it gets to a certain number of votes, you have a vote on it. The government gives its position. The government advises people how to vote, but you can vote against the government, and whatever is voted for becomes law. That's what I would like to see. I will concede that the society, people need to be informed and responsible for that to work. But I understand your point here about it's not logically deducible that everyone's vote should count equally, because clearly there are people who are more qualified than others to vote. That's undeniable. We just have to have that as a fair system, and there's no choice. But when it comes to the jury, I absolutely agree with you that it is just 12 people. It's just the language of court where they continually say, "Oh, the jury." You've heard Liz Hull repeating it, where I'm taking the Michael out of her. At the end of the day, it's just 12 people who get a letter saying turn up to court, and then they sit there and they do their best. Of course they can get things wrong. Of course they can. Lucy's fate was already sealed before the trial began, all through the police investigations and the hostile trial. She was ignored or her words twisted, but they had to combine their efforts to get the verdicts they wanted from a jury that was totally misled throughout. Goss has a lot to answer for. So I definitely think the judge made decisions that went against Lucy. Well, numerous decisions, but there's no point in dwelling on this too much. We can't change it. The fact is, he hasn't done anything that's not allowable legally. Lucy's been convicted. That's the world we're living in. We haven't got a time machine, so we've just got to deal with it. I spent 50 years believing that some of the fictional judges created by John Morton and QC were comically exaggerated caricatures. I was wrong about that, wasn't I? So I don't know who John Mortimer QC is or what he wrote, but I think historically there have been issues with the judiciary. There's the very famous comment from the judge in the Birmingham 6 case about basically it's more important we preserve faith in the system than get these innocent people out of prison. And I think that attitude does still prevail to a certain extent, even though it wouldn't be expressed as gauchely today. but I do think that attitude still does prevail. Hi Chris, as a tangent to this, I'd love for you to talk more about the serial killer angle. At the time of the trial, I remember a lot of true crime influencers covering the case. There was a huge interest in the idea of a sweet-looking blonde serial killer hiding in plain sight. I genuinely think people got excited over it, maybe an unseemly word, but I think it tracks. So all of those silly bits of evidence you hate, the Facebook searches, the handover sheets, the secret boyfriend, those all slotted into a narrative that people felt they understood. We've all seen Silence of the Lambs, Seven, Zodiac. Viewing the handover sheets as trophies probably didn't seem like much of a stretch for a public who've been raised on packaged crime as entertainment. People are very quick to jump onto a theory they think they already know something about, and I do think there was a form of entertainment in it. There still is, to be honest. I have to remind myself sometimes that this is real life. Lucy's a real person going through genuine torment. So I think a lot of very interesting and intuitive points there. So the first thing I'll say in relation to this is that I'm actually interested in true crime and criminology. I think if I wasn't a writer, probably my number 2 job that I'd like to do would be a criminal psychologist. I'm very interested in why people do extreme things that are outside of the norms of society. So I've studied many serial killer cases. I've studied other extreme crimes. And I would still like to make some content about that one day. At the moment, I'm just very focused on doing Lucy and Lucy's case. One thing I wanted to show you one day was how the writings of serial killers differ so much from what Lucy wrote. Maybe I'll make that video one day. But yeah, I was very interested in this. But for me, I'm always interested in all these things like true crime, criminology, however you want to describe it, these extreme crimes that take place. I'm always interested in why the person commits the crimes. So I think that was one of the key routes into Lucy Letby's case was I couldn't see an explanation for it. It was a major red flag that she didn't look like the type of person who would be a serial killer, to say the least. I mean, that's an understatement. So for me, it's not that I became... Maybe it's because but I don't think I would have done anyway, but I didn't follow the trial, I just heard the verdict. So I never had the experience of getting excited, but even so, I would always be looking at it critically and thinking, why has Lucy Letby supposedly, harmed these babies? Why? Why has she done this? And there is no answer. There is no motive. So for me, that was very interesting, but I think when you talk about the story and the narrative, you're absolutely right. People do stitch together these trivial aspects and create a narrative in their head that is compelling. And I've got some stuff in my book about an expert on juries who says basically the jury just comes up with a story. They're sold a story, and they just decide which story they like the best. And one of the big problems in Lucy's case was the prosecution told a great story and the defence didn't tell any story at all. And so when you actually observe the way the public, who are not part of the jury, of course, interpret this case initially, it's absolutely buying into the narrative, as you rightly say. And then I definitely think it's a particularly perceptive point you've made about the prevalence of serial killers. And it's not just serial killers as well. It's very stylized, weird things that happen in these films, so they become compelling. So in Silence of the Lambs, there's some very strange thing that goes on. I know, isn't there a victim that likes to dress in the skin of his victims or something horrible? But and in Seven, it's all related to the 7 deadly sins, and there's these increasingly bizarre crimes related to people who the murderer decides were guilty of, gluttony or whatever it is. So yeah, I do think that can absolutely be a contributing factor, and I think people get very fixated and immersed in these things. Not just in film. There are very popular. I mean, let's be honest. Murder and death and violence are incredibly disproportionately represented on television as well, and of course in movies, and in cinema. compared to actually how much violence there is in your life. Like there's hardly been any violence in my life. None of it was perpetrated by me. I've witnessed bits and pieces here and there from time to time, but I can't remember the last time I witnessed violence. It was a long time ago. But if you turn on the TV, it's just constant, relentless. And I know I live in a quiet part of the world. It's different for the people. I understand that. But I would still say TV and media, generally, completely disproportionately represents the amount of violence and of course murder. So I do think that can be a major factor. And you're right that people are quick to jump onto a theory they think they understand. It's all very bizarre, but a lot of it is just human nature, and it's just the way that we understand things. And for whatever reason, people get a few small details and they think, oh, yeah, of course she did it. What, she's written something in a diary. Or why did she take those sheets home? I get sick of hearing about it, but there you go. Can you attempt to refute the arguments I've heard for a killer in plain sight? I've seen people talk about Lucy's ordinary background being a perfect cover, as though she was a childhood psychopath. One particular true crime YouTuber stated that Lucy's parents must have smothered her with their affection, as though they loved her too much and it drove her to kill. And finally, the tendency to end every argument with, well, she's a psychopath, to me, that sentence is a death knell for critical thinking. So all of the statements that you've made here, that you've heard other people saying and that you're referencing, I mean, they're all just trash, total rubbish. Let's take them one by one. The idea that Lucy has thought, oh, I've got an ordinary background, so now I can go around killing babies because people will just see me as an ordinary person, so therefore I'll get away with it. What kind of person would ever think, or it's just not going to happen. It's just absolute crap. The idea that Lucy's parents smothered her with affection, what does that have to do with anything? Nothing. That would be, she might be a bit spoiled, like Veruca Salt in Charlie and the Chocolate Factory. She wouldn't kill people because her parents smothered her with affection. It seems that her parents were particularly fond of her. It seems that her parents were particularly proud of her, and they may have given her an excessive amount of affection. But that would just make her like a little bit soft and a little bit spoiled. It wouldn't make her want to kill people. The psychopath, I've dealt with the psychopathy angle in my book. There's just no evidence for that. There's no evidence for borderline personality disorder. These are just unevidenced claims that have no merit whatsoever. What is the status of immunoassay test results in coroner's court? I can't answer this question precisely because I'm not sure how the coroner will look at this. All I know is that it's not a forensic test and it shouldn't be used as proof of insulin poisoning. And if a coroner was looking for proof that insulin was the cause of death, they should look beyond immunoassays. No doubt. Everyone knows that. Undeniable. The Post Office Horizon Systems Offences Bill was passed in Parliament to quash convictions of those affected by the Post Office Horizon scandal. Surely they can do the same for Lucy. So the difference between those two things is that with the Post Office, they'd reached a level of public penetration and acceptance that the sub-postmasters were innocent, that hasn't occurred with Lucy. It was kind of officially rubber stamped in a way. So that's why Parliament were willing to pass that legislation. With Lucy, we're not at that level yet, and it's been clear that although there must be a lot of people in Parliament who know this is an unsafe conviction, a political intervention doesn't seem likely at this point in time. You're right to say they could do the same for Lucy, but we haven't encountered any MPs yet other than Sir David Davis who are willing to speak out. Thankfully, we've got Sir David Davis. That's enormously helpful. But I don't see this as being a likely avenue, and certainly not in the foreseeable future, and we hope to get her out of prison before it's necessary. Do you agree that this case will grow in magnitude as the realisation of the sweeping harm caused becomes ever clearer? Yes, it will. Obviously, it should be our aim as campaigners to ensure that it remains in the media, gets bigger and bigger, more and more people know about it. If anything, we should try and make it international. And then when Lucy's exonerated, this will, as I've said numerous times, will go down in British history for hundreds of years, not decades. This will, long after we're all under the ground or cremated or wherever we are, this will be talked about, and this will be part of British history, and it'll be taught in universities, and it'll be case studies across multiple subjects. This will not be forgotten about. What exactly was the extra evidence from Holt, Brewery and Jayaram on the 15th which piqued the police into action exploring this as appeal fodder? The amount of sorrow, time and money this has cost requires an answer. So it is the Child K tube extubation case. This is what Jayaram referenced with regard to the phrase piqued the police into action. If you mean what convinced the police in that meeting to investigate, one can only imagine. There is no specific answer to that question. All I can say is the consultants walked into the police station and the police accepted what they said uncritically and then very rapidly decided to launch an investigation, essentially due to their stupidity and incompetence as well, I should add. There's nothing else I can say. There is no acceptable answer to your question. That's the best I can do. Also, if Evans was not registered at the time and he was essentially a civilian, does this negate his crime agency status, and is evidence then admissible in retrospect for a system looking for ways to save face may be useful? Well, this is an interesting question. Evans is a very vulnerable person who could be used as a fall guy, who could be used as a scapegoat. Everyone could... I mean... Let's be fair. The police will stab him in the back so quickly they'll forget to stab him in the back and stab him in the front if they have to. I don't know if this would happen, but he is very vulnerable because the whole case has been hung on him, and we're learning more and more stuff that makes this clearer and clearer. So he's in a very vulnerable position indeed. There is no precedent because there has never been an abuse of process and power seen before as powerfully delivered to the whole nation like this. Inquiries as to what went wrong in all other areas can follow at a less alacritous pace. They are pretty useless as they are ignored over various periods of time. Even Thirlwall was unintentionally useful for being forthcoming with process issues where errors can be worked out. Its reported items are disappearing from the inquiry website. If so, the chair may be removing the bits which she may well be commended most for uncovering and is able to include in her final report. Doesn't a senior inquiry chair have a duty to the court to provide honest comment, whether reluctantly against outside her original intentional remit, if it's important towards restoring injury to the reputation of the judiciary? A very interesting question again. I don't know is the answer to this question. Lady Thirlwall will argue, here are the terms of what I've been asked to do. I must operate within those terms. Morally and ethically, obviously she does have a duty to do what you have described. Whether or not she has a legal duty to do that, I don't know. I suspect she can just say, this is what I've been asked to do, I'm doing it, and if indeed I don't do it, then I'm not doing my job. The whole notion of duty, I agree with you. I agree with you that she has a duty, but she may see her duty as to fulfil the terms of the inquiry as they're laid out as the chair of that inquiry. So she may see that as usurping all other duties, including a moral and ethical duty. I think is the only way to answer that question. The question is, how can this juggernaut of broken justice be stopped? Can the various competing institutions, including the police, stop the investigations into the managers and at Liverpool Women's Hospital? Surely the CPS have to make decisions soon, or can it just be an open-ended case forever? So the police can't stop it now, or won't, because they've submitted to the Crown Prosecution Service. The CPS don't have a time frame as such. As to whether it can be an open-ended case forever, I don't really think so, because that would be ridiculous. At some point, they're going to have to say publicly, we're not going to advance this case, or we are. I mean, surely they're not going to advance it at this point. It would be absurd. I don't think there's any pressure on them to do that immediately, because cases can remain with them for a very long time. But it can't remain there for 20 years, open-ended, and they're just saying, oh, we're still investigating. I don't know what the time limit is. I don't think there is an official time limit, but they're going to have to do something eventually. It's kind of like the Manchester City charges case. Are we ever going to hear the outcome of that case? I know some of you probably don't follow football, but they've been accused of financial misrepresentation of their revenue. And everyone expected it to have been heard by now. Really, honestly, it should have been heard before the start of this season, and for the results have been published, and it hasn't. So it's just going on. So one day there's just going to be this bombshell where someone says, oh, Manchester City are guilty or Manchester City are innocent, but no one knows when that's going to be. So it's a strange situation, but we'll just have to wait and see what happens. So we're on the final few questions here, but I do want to give a fairly lengthy answer to this question. Do you ever worry that you and I and the rest of the pro-innocence camp might also be in a bubble? So that's a very good question, and it should absolutely be a concern that we are. And effectively the answer is yes, we are in a bubble. Of course we're in a bubble because we're a group that's campaigning for something and we all share the same perspective. It's a classic example of an echo chamber. For me personally, all I can say is, let me emphasise before I say this as well, as I mentioned earlier, no one is completely objective. That is impossible. No one can be objective. So we're all seeing this through a certain tinted spectacle of some form, because we are invested in this notion that this is a miscarriage of justice. And I wish to try to be objective enough to say that. The difference, or what I really feel I need to mention as well, is that all the time that I've been doing this, I've been looking for the critical evidence that points to guilt. And I'm always aware of the fact that I'm seeing things through this innocence or miscarriage of justice lens. And, frankly, when I decided to write a book, and when I realised that I wanted to do that to a certain level and achieve certain things from it, otherwise there's no point in doing it, I realised that there would come a point where I was no longer anonymous. Now, I've had a nice life as a ghostwriter and a freelance writer for 15 years, and it reminds me a bit of something Noel Gallagher said about being an oasis. He said, I used to be a roadie and I could just do whatever I wanted. No one was bothered. No one wanted to take my photograph. No one cared what recreational substances I was using. All I had to do was turn up, tune the guitars, and then, get wasted. It was great. So as soon as I was in Oasis, although that was obviously fantastic, all of a sudden I had to behave more sensibly. Now, I don't want to pretend that I was anything like that. I definitely am not. I'm not in any way rock and roll. I'm quite a nerdy person, frankly, and I've always had intellectual interests and led a very quiet life. But I was completely anonymous, and I had no desire to change that. I have no desire to have any form of notoriety. And when I decided I was going to write a book and I knew it had to be done properly, I obviously thought about it, and I thought, are you willing to change your life so that people know who you are and you're not anonymous anymore? And I decided, yes, I am willing, because this is very important and I'm passionate about it, and whatever changes I have to deal with, I'll deal with them. So I would never volunteer to be in this position of being known necessarily. It's just something that I know it's very small at the moment, but it's going to get bigger. And, that's not something I would have signed up for. I never would have signed up for being famous. I never would have been queuing up for the X Factor or something. That's just not going to happen. It's my idea of a nightmare to have that level of fame. So if I'm going to do that, if I'm going to change my life, I'm going to be on the public stage on such a contentious issue that is so obviously controversial, then I want to be very, very certain that I'm correct. So I've been looking all the time for the red flag that says that Lucy's guilty, for the real cast iron item of evidence that points to guilt, the strong argument from the prosecution or the pro-guilty people, and it just doesn't exist. It simply does not exist. So I think it's fair to ask whether we're in a bubble, and I think it's reasonable to describe what we're in as a bubble. But I have exposed myself to every conceivable pro-guilty argument personally, and they just don't hold any water. They've got more holes in than a colander. So for me, I'm not too concerned about that, but I think it's a very important question to ask, and it's something that we do need to be aware of. So just the last two questions. As much as I don't pretend to understand the details of the law on this matter and don't wish to make criminal accusations, I feel there must have been collusion. So obviously a lot of people have said this. I can't endorse that. I can't prove that. And I'm not sure that it happened anyway. There are many other explanations for what occurred. I understand why people say this, and I never stop people from saying this in the comments, but I don't wish to endorse that. I understand why you feel the way you do. I understand why other people feel that way. But there are other explanations other than direct collusion. Stephen Phelps discussed some of them. There are other possible explanations, and coincidence is always possible. The biggest thing for me, really, is the rashes used as evidence of her embolism that were so allegedly unusual and yet not even recorded at the time. I find it extremely hard to believe that there wasn't collusion to bolster the case. Yes, so obviously I don't endorse the idea that it was collusion. I must emphasise that again. It is strange that the rashes were not used in evidence at the time or written down at the time, but we do know that Jayaram did some rudimentary investigation into this, so perhaps he did have concerns, albeit those concerns were poorly founded and misguided. Essentially, regarding the law, if a load of people got together and conspired to put false allegations in a court case, and they knew they were false, that would be a criminal conspiracy, and there are laws related to this. Would be a very serious offence, but I don't think we're looking at anything that would be remotely like that. So I must make that crystal clear. I think, as I've said, I don't believe the consultants wished to frame Lucy at all. I think they're genuine concerns, and it's just been one massive confirmation bias in the hospital, and then it's been another massive confirmation bias in the police. And I'm going to be bringing guests on to discuss this in the foreseeable future, so I will expand on this further still. So I've made it to the end. I knew this was going to take a while, but I think I've done it in under 2 hours. So I hope you've enjoyed this, and I've already saved numerous questions for my next session, which will probably be in December at some point. If you have any comments, queries, comments, more questions, please do leave them in the comment section, and I'll look forward to reading your remarks.